top 5 secrets for resolving your client's case at full value in the claim stage of the case. These are techniques that you've developed over the years. And then when you and I start talking about it, I do the same thing already at a lot of these. So, but go ahead, let's go with the first one, Steve.
Okay, so before I begin into any of these, not every one of these applies to all cases. So you have to understand that sometimes these things won't work every time. But on the whole, hopefully as I go through these, and if you have some personal injury cases that you're working on, you'll be able to see that maybe one of these applies to that specific case. So the first one is, I like to try to anchor the value of my case early as quickly as possible. And I do that to make sure that the adjuster doesn't set the reserves low in the beginning. And that's really important. I know there is a principle called anchoring out there that applies to trials, and most people understand that trial lawyers understand that they maybe don't want to introduce medical bills because it might set the jurors' expectations as to the case value on a lower amount. But going back to I always think of anchoring in speaking. You're anchoring to places, you're anchoring to numbers, you're anchoring to a picture in a trial, you're anchoring to something, there's certain things that anchor, that zone in on things. But what I like about this that I hadn't really thought about, I understand about setting reserves and stuff, but the idea of anchoring the claim rep from the beginning, why is that important? It's important because there is behavioral economists that have done studies out there that show the first number that people put on something that's uncertain is usually the most important. And this isn't necessarily true if you have something like a car where the market can kind of well define it, but something like a personal injury case where there's many factors that go into it that make it difficult to readily ascertain how much it's worth. So as the adjusters are setting the reserves for different cases, I think they can sometimes set case values low when they really should be higher, and the attorney could have from the onset communicated the reasons why the case should be selling for more. So something I like to do.
So what do you do to anchor them early?
Well, you should send, as soon as you know, so in detail, a communication to the adjuster saying how the injury is affecting your client's life and why it's worth what you believe it to be worth. And that is going to somewhat come into play with the second concept we're going to talk about in a minute here, which I'm not quite ready to get into, and that is knowing the policy limit.
Right. So you want to say, so like if you have a broken bone, you have a herniated disc on MRI, you have these bad things, you want to tell them about that right away.
Not just tell them, but show them. So a lot of people think adjusters are evil people that just don't want to pay you a fair amount for your client. And
hey, I'm right here. You're talking about me. What are you doing, dude?
That's right sometimes true, but on the aggregate, I think most of the time they are just overworked people who need to document their file so that they can survive an audit later on. And they're not going to give you policy limits, even if you have the policy limits case, without showing some documentation. So you can get policy limits early if you provide them the right documentation. And so if I have a client with an MRI that shows they have herniation, and we know the policy limit is only $25,000, send the MRI as soon as you get it, as soon as you know it, and allow them to help you.
So one of the things that we do sometimes is we get all the records and then we send the records as a group into the adjuster, and sometimes that's not good because, and I was just settling a case the other day, and they're giving me low numbers. I'm like, but look at this MRI. It's got a herniated disc, and I know the medical wasn't that bad, but they treated only, and then they're not going to get a surgery, so they're kind of done. They went back to work, but getting that adjuster to give me the value for that herniated disc was an uphill battle. And sometimes I find myself having to file suit, get a new adjuster on board, getting a lawyer on board before they say, you know what, it's herniated disc. This person they're going to need injections once a year for the rest of their life, or whatever it ends up being. We need to value it that higher. But what I like about this idea is you want to anchor that adjuster in the beginning, because the other part of anchoring is that once you anchor someone on an idea, when the rest of the information starts coming to them, their brain is it's cognitive dissonance, right? Their brain is going to filter out things that they disagree with, that don't support that conclusion, but accept things that they do agree with. That happens in trials all the time. You want them to like your position right away, and as they get more information in, they're going to filter out things that disagree with their first impression versus that. So I think that's great. What do you do? Sorry, go ahead.
Oh, so the other thing I was going to say on this subject, I went to a personal injury lawyer group recently, in the national group. They kind of give practice tips, and one of the things they were saying they do is they also use this concept, but they don't even let the insurance company know that they're representing their client until they have exact knowledge of what the client's injuries are. And
you say
well,
that in the materials, so that when you do your first, go ahead, I know.
Their theory is that they feel so strong about anchoring that they wait until they know and they can articulate why their client's case or whatever they want it to be in their very first communication.
Do you do that?
I do not do that, because I think that's I mean, it would be ideal if you could do that, but in practice, in reality, it's not really on the table most of the time. Most people care about their property damage, and that's true of bigger and small cases I've had throughout my career. And if you have property damage, you need to set up that claim for your client, and you are not going to have the luxury of waiting 6 months until you know if your client's case is a certain value to communicate with the insurance company. So what I like to try to do is I send a letter with language saying, talk to my client directly, set up the property damage, but then say, we are still finding out the nature of my client's injuries. As soon as I find out the severity, we'll be in touch. And then as soon as I know, I will let the adjuster know via a phone call, via an email. And then, as I said before, back up everything that you were saying as soon as you can.
With the records. You say that at the bottom of page 2 of our material. I think it depends on the case too. If it's a case where it's a $25,000 or $50,000 case, I think you get that lien letter in right away. Your client wants to know you're doing that. They don't want to get, you need to tell them that, because you don't want your client to keep getting calls from the insurance company going, do you have a lawyer? Well, and you haven't sent that letter. So getting that, then they're not going to take their statement. They're going to stay away from them. Those are important things. I don't know about the other CLE, which I get the idea, but if you have a $5 million policy or a truck crash case, that may be different. You may want to wait a month or two to tell them that there wasn't only this broken bone, and there wasn't a TBI, but now there's this issue and this issue and this issue to anchor the adjuster. And then also if you file suit or you get to a new adjuster, you want to anchor them right away too. But we do that all the time. When I get an adjuster, or you can also call the adjuster too. They'll call you on the phone, even if it's not in your lien letter. They'll want to know generally, and you want to say, listen, it's a significant case. They have tingling in their arms and hands. It's not just a whiplash. Did they? I know the ambulance report in the first ER visit may not say they hit their head, but they went to a neurologist 5 days later, and they can't remember things and they can't work, or blah blah blah. Those head injuries, you need to set that stage right away, because that can be a little bit amorphous. Sometimes it's hard to get full value for those unless you do it right. Well, that's great.
I think one last note on that. I think that if you don't do it on certain cases, you run the risk of having to potentially litigate it later if they're saying the case is only worth however they evaluate it to be lower. And so I think sometimes in the same fact pattern, Some lawyers may be able to settle a case earlier than others, just based on these initial stages of representational.
And remember that they're setting their reserves. They're doing an initial evaluation. They're setting reserves and sometimes that's hard to move the needle on that. It really is. And I run into that all the time. And then you gotta change their mindset. What's your next? Anything else on that tip?
That's it for now.
Stephen?
For tip 2, this is an area which depends on your case. Some insurance companies will give you it, others won't, and that's finding out the policy limits. Because I feel like you cannot get full value for your client unless you know what the policy limits are, or you at least have some idea. And from my experience, I don't always get told what the policy limits are early on. Often they say, well, my insured won't disclose it to me. And then you're left with trying to figure out what to do. And often that requires filing a lawsuit to find out that way. But on the cases that you can know what the policy limits are, you're usually able to dictate your negotiation strategies based on that number. And to give you an example, if you have a case that broken bone is obviously $25,000, you can know pretty early on that you got full value for your client if they send over the limits. But if it's a case of broken bones and $250,000 limits, you may not be able to act as quickly to know what the best thing to do for your client will be.
Can I jump into? Remember though, too, on topic 1, if you're trying to set them up for bad faith, remember that you don't have to tell them all the medical necessarily under the statute. You just have to give them the authorization. You say you can tell them you got a broken bone, but they may not know your client needed 4 surgeries to get hardware and stuff to get better if you're trying to set up for bad faith. Now, most clients don't want to go the route for bad faith down the road. And I was joking about adjusters, but a lot of times adjusters and defense lawyers want to settle these cases fairly. They need to have the ammo to their supervisors and their files to justify that. So you gotta play that part. And I get this all the time where if an adjuster isn't, I see it. I had this conversation yesterday. The adjuster offers you something low. I pick up the phone, I call the adjuster and I said, what's the disconnect? What am I missing? I had this yesterday. They offered me low amount. And then they said, oh, we're doing this on 50-50 liability because there was a phantom vehicle. Well, that let me know why their offer was low. Then we're putting the uninsured motorist of my client on notice and trying to get, and I said to the adjuster, send me an email saying it's 50-50 so I can send that to the uninsured motorist. If you have multiple parties communicating about that, what's the hang up? Or having a conversation this too. Well, when I first got, this case, I thought, it was whiplash. I didn't understand the other medical, and then the adjuster's having a problem paying you. And then you need to say, well, listen, I'm sorry. When I first talked to you, I didn't know. And we have all this medical. We have an MRI. We've gotten 3 injections now. Here, let me give you that. So even if they're anchored once, you want to move that anchor another time and give them a reason to make it easy for them, which is exactly what you're saying. Jump into point 2. Let's recall that in Missouri, the adjusters do not have to tell you the policy limits. They do not have to. In Illinois, they do. In Illinois, there is a regulation, and if you email me, I can give it to you. I'm not sure if I put it. I have it in other materials. There's a regulation where they're required to give you the limits. In Missouri, most of the, I'd say probably 60 to 7% of the time, they end up giving me the limits because they want to see a justification for it. So if you get a person with 1 ER and nothing more, and there's 250 limits, you're not going to get the limits. But if you could show them that this is the kind of case that warrants it, I've had many letters where, although the medical may not be high, I sent them the MRI and I said, this is a herniated disc. This is lifelong problems. They're having radiating pain in their hands. Although their care is what it is, they're going to need to do more. They're going to need injections down the road. So that's another way to get the policy limits. The other way I get policy limits in Missouri is I tell them I'm going to file suit. I say, listen, this is a case. I'm kind of shooting in the dark. You're exactly right on policy limits. And I'm kind of shooting in the dark, but I need to know this. And if they won't, then either I say, listen, I'm the kind of, you know, I'm grumpy enough. I'm whatever. I'm steadfast enough to file suit to get policy limits. And I've had cases where I filed suit and I serve one interrogatory. What's the policy limits? And then they give it to him. Many times those cases settle. And the other thing about policy limits, and then I know I interrupted you, but and then you need to, and this is going to get a couple points down for what, and I'm not stealing your thunder, Stephen, but you need to help your client with the medical care. So you're going to need to make decisions early on in the case about how much medical care to get. Knowing the policy limits informs you of that. If it's a $25,000 case, you can't have them go get $25,000 worth of PT care. It just doesn't work that way. And that's, you're making decisions on medical care on a lien basis, medical care on home health, personal insurance. There's a lot of decisions going into that. So that, and sometimes you just can't do it. So you kind of do your best. What I do if I don't know the limits, I kind of do my best. We kind of get the MRI, we do this care, and then, but then that'll inform you as to where you go. If it's an MRI showing a frank herniated disc, then you know what, you got to do that. And then, oh, here's the other trick on getting policy limits is tell them you have an underinsured motorist coverage claim. Were you going to say this already?
I was
sorry.
not saying it.
Sorry. So you say to the adjuster, say, listen, I get that you don't want to tell me. And you know what, in Missouri, you don't have to. But here's the deal. My client has underinsured motorist coverage of a high limit. And I am never settling this case until I know the limits, until I get an affidavit from your client that these are the limits. There's no homeowners or excess policy and stuff, because I got an underinsured claim. I've already done the lien letter, boom. The other thing you do is you, oh, now you project. So, you know, I've spoken long enough. Go ahead. Tell me what you got.
With the affidavit of no excess coverage, that's very important if you settle a case for the policy limits. But I did some research to find out, you know, how high the underlying limits have to be, and it appears that $250,000 is the amount that an insurance company needs before they will sell someone excess or umbrella insurance coverage. I think it used to be lower, and I had a case recently that I wasn't able to find out that there was an umbrella coverage, and I got $100,000 more from my client because of this. Because some policies may be grandfathered in. So I encourage you, and that's point number 3, to have the insured file an affidavit of no excess coverage. You may find more money available for your client there, and they may not always have underinsured motorists. Many times people don't. It's an elective insurance coverage in Missouri. So that allows you to get another avenue of recovery for your client.
So can we, let's take it, what is an affidavit of no other insurance? Why would you want to get that anyway? Just starting from the basics just for a second.
Well, if you have a case that's worth at least the policy limits for the third party coverage, you need to find out if there's more coverage available for your client, if it's worth more than that amount, whatever it may be. So as we said before, this doesn't apply to every case. You're not going to need underinsured motorists or excess umbrella coverage in every case. But if it's worth at least the third party limits and the case is worth more, you are finding out if the insurance company, some insurance company can pay more. And that's important because your client's unlikely to get a recovery against the individual that caused the accident directly. So you want an insurance company to pay that. And that's why it's important.
Right, and just to talk about that just a little. So the affidavit, if they say my policy limits are 25 or 50, and if you're prepared to take that, you ask that the insured provide an app, and I have these forms. If you want a form for this, email Gary at Burger Law or Stephen at
GerringLaw.com.
GERRINGLAW.com. And I'll put this in the margin here in a minute. And then they sign an affidavit that they have no other insurance, because if they do that, you're covered with your client that you've taken the policy limits, but also you're set up to do an underinsured motorist coverage claim, because you don't want to settle for 25, make an underinsured claim, and then them call you and say, yeah, but the wife had car insurance and that also from the defendant, and that acted as a secondary insurance, so you could have gone after that. Or they had a excess or umbrella policy, or yes, they had this, but they also had another coverage. So getting that affidavit, and I've had cases where they've gone after it and they found more insurance. And then you just mentioned that you did too. So then we were able to get that. So it's a way to close that loop.
So some underinsured motorist policies require that you exhaust all of the coverages first. So that's another important practice point. That you may need that affidavit to proceed on the underinsured motorist.
Yes. Yeah.
And then the second thing I want to point out, practice area, or practice tip that I learned the hard way. When
Isn't that how we learn everything?
Yes. When emailing over the affidavit of no excess coverage, make sure that you let the insurance company know that if they offer you policy limits on underlying claim, make sure they know that your acceptance of that is contingent upon their insured signing the affidavit of no excess coverage. I had this issue pop up where my client wanted to get the policy limits, but they also wanted to find that information out. And the way that ended up working out was the adjuster said, yeah, we'll do that. So get compliant, but then they sent the check to my firm and the release, and my client signed the release, and the affidavit of no excess coverage didn't come. And I got the check deposited in my old account prior to dispersing to my client, and they're saying, well, we still want to see that affidavit, and the insurance company would not produce it. And so I eventually had to file a lawsuit. The defense
Good job.
lawyer said, oh, well, this matter settled. And they pointed to the language in my email, which I think was pretty clear on my side, but they said it's debatable. They ended up producing the affidavit of no excess coverage, but it was after months of nervousness on all sides, because my client really wanted to see that. And like I said, they complied with it initially. They said they would do it. We wouldn't have a problem with it. So the way to avoid that is make sure that your email is crystal clear, that your client's acceptance of the policy limits is contingent upon the insured signing that affidavit.
And again, it depends on the case. If you have a case with 200 grand in medical and they're saying there's a $25,000 limit, this is where all this comes into play. And then remember too, the other arrow in your quiver is the bad faith statute, where we have the form letter to set them up for bad faith, and you say, I need to know your policy limits because I'm about to send you a bad faith letter. That if you're, so let's say you got a case, if there's 50,000 in limits, they're offering you 30 and they're bogged down and they're not doing it, and you think the case should sell at 50. You say, listen, I'm never not taking less than 50. Genevieve Fikes, who's on this call, had a great case where they kept trying to inch up to the limits. She said, no, I'm never taking a dime under the limits. And then they ended up paying. We litigated for a year or whatever. But we used the things like, and we sent the bad faith letter. I need to know the limits because under the statute, I'm sending you a bad faith letter. I'm going to give you 90 days to do it. We're going to give you the authorizations. We're going to list the medical providers. We're going to do everything under the Missouri statute to do that. So that's another way to get limits. That's another way to talk about policy limits, signing that affidavit, another way to get around these two issues on limits. But ultimately, if And you just talk to the adjuster, you try to get it, you're better at, I think you're more patient with adjusters than me probably, but you're nodding. But ultimately, sometimes I just say, I'm filing suit, and then we're set up for, you file suit, litigate too, but you file suit, and then you just file suit and send that one ROG and say, what's your limits? And then they tell you, and you say, well, why didn't you tell me this before? Then you engage in a conversation. But using that UIM as leverage, for some reason, and you know what I've done too is I've sent the adjuster from the tortfeasor, I send them the UIM adjuster. I'm not just making this up. Here's the UIM adjuster. Here's their name. Here's their claim number. They're not going to pay me a dime unless they get the full limits from you. and sometimes that works. And then the other thing you do is don't wait to make the UIM claim until the tortfeasor, until the first defendant is done. You don't wait. Send that UIM claim right away. When you do a demand to the tortfeasor's insurance, you can send the same demand to the UIM and just say, let you know, we're sending this demand to these folks, but you're next in line once we complete this thing. And then we always remember too is, I don't think you need it for every policy, but you do on some. So we always tell the UIM adjuster that you're about to settle the case against the tortfeasor and get them not to object. So while you're doing you know this too, right? While you're getting and this is on point 3, while you're getting the affidavit of no excess umbrella, the other thing you're doing is you're getting approval from the UIM adjuster to settle the underlying case. So then they know that's settled, because sometimes there's set-off issues, there's other things that are coming up. So that's another thing.
Good point.
Yes, thank you. Are we ready? Anything else on through points 3, Stephen?
I don't think so. Point 4, it's not an original line of mine. I heard it recently, but I really like it. And that is, you don't need to be a medical expert, but you need to be an expert on your client's injury. And I think that this is maybe the most important thing to do to get hired in case studies.
Is knowing the medical.
Knowing the medical, doing the homework, understanding what the differential diagnosis is, understanding what the diagnosis is, knowing what the injury is, knowing how that injury specifically impacted your client. And that can vary. And I think it's worth mentioning that there are a lot of varieties of clients in terms of tolerance for pain and how often they want to go to the doctor, for example. So I know personally, I'm not someone who goes to the doctor a lot. I probably wouldn't go, see a chiropractor 30 times after an accident, a low end accident. But many people do, and that doesn't mean they're wrong for doing so. Sometimes people are more prone to wanting more healthcare treatment than others, and oftentimes it's reasonable. As we saw with COVID, different people have different theories about the best way to handle things, and some both of them are right. Both extremes sometimes can be right. So that is important to note for all of these tips. I think this sometimes you will have clients that won't treat as often, and you don't have that record to show the insurance company. So if you get to know your client better, you get to know what they do, you get to know maybe their lifestyle a little bit, you're able to better articulate what this injury took from you. And I think the importance of this is that you keep hammering that home versus getting on the defensive with the things the insurance companies always use when they counter. And that are things like low impact or no proper damage, or we only accept 10 treatments for injuries like this because of these guidelines that are very defense friendly, or they evaluate the case solely on the specials using the diagnostic codes. And insurance companies have invested a lot of money to evaluate cases using these codes. So what you can sometimes get in the trap of doing is arguing against them on these points versus advocating the loss. And I think that's important here. Important distinction to make is that you should try to advocate the loss more than defend because on almost any case, they're going to be able to find something. Maybe one of these that I just mentioned that really takes away from your client's value. And if you get trapped up in thinking what they want you to accept less for, then you may eventually do just that. So
yeah, go ahead.
So I was going to say the important thing on all these cases is you have to do the homework of knowing what your client's injury is, how it specifically impacts them. And there really is no shortcut to this. It usually takes a lot of work. You only don't know things first day after you sign up a case. There's rare instances where you do. Sometimes you get great cases that you know quickly, and that's great. But often, we're more or less piecing things together over time.
Can I add something to that?
Sure.
So one of the things I like about in your material is there's no shortcuts to this. There's no hacks. You got to put in the time to know the injury. And let me bring it a little bit bigger on the injury. So you want to be able to talk to the adjuster about, if you have a brain injury, if you have, does it say concussion in the ER records? Yeah, but you need to be able to talk to them about what that means. That means they can't remember. Some people get changed personality. It's really frustrating. My client has to bring a pad of paper all the time to remember stuff. Excuse me.
Concussions is a big one for what I'm talking about here, because you'll often have concussion, emergency room diagnosis, and then no follow-up treatment for that for months after.
Because they don't know. People don't, and you go to a doctor and they say, well, wait it out. What am I going to do? There are programs. There's a great head injury institute at WashU. There's other programming you can do, but most doctors are going to let it sit for a while. It's like conservative care. You're not going to go operate on a herniated disc. They're going to wait to see if the person's symptomatic. They're going to wait to see if that TBI organically resolves itself. But if someone 3, 4, 6 months later can't remember names, can't talk, still has short-term memory deficits, then they start doing the reprogramming. I was talking to a client just the other day who had to have reprogramming to get his eye working again, and he told me all the details. And getting into those details was I'm never, just pick up the phone, you can read it in the medical records, but pick up the phone and go through it with your client and get the real boots on the ground story so that you can talk about that. The other thing you can do, if you know the medical, and I use this all the time, is they're not settling. And I say, listen, here's the deal. My client's already done 2 rounds. You did a round of chiropractic care 4 months after, another one 4 months after they stopped the other time. I said, yeah, and you know what? You better settle this case now, because if you don't settle this case in a year, my client's going to have 3 more rounds of PT or chiro, and they're going to get more objections. So if this person's going to keep treating, this is going to get worse for you, not better. That's the other thing about knowing the medical, a little trick I do. And look, by the time, if we file a suit now, they may get knee surgery by then because their knee is popping out. This is the cheapest and the best you're ever going to get out of this case. So you want to know the prognosis in the medical too in the future. So settle now or there will be more treatment. The other thing you want to know is, if you know the medical, you know that if someone has a knee injury, well, when they get that MRI and they have that torn meniscus, they're going to get a scope operation. Or if they have a broken bone, that's going to ache in the future. That's going to have problems. Maybe you got the growth plate in a kid. If there's a brain injury, we already talked a little bit about the medicine on that. If you have a case with the surgery for a herniated disc, every doctor, even defense doctors, are going to say that puts more trauma on the disc below and above the fusion, and they may need a second fusion surgery in 15 to 20 years. So knowing the medicine and the future damages also gives you a hammer on the adjuster to do that. The other thing is that I get this all the time. They say, and I love your statements. You know what? He says this, and Stephen says some good. The bullshit that they throw at you when they're trying to settle the case. So, we're only accepting 6 weeks of treatment. We're accepting this bill. We're not accepting this bill, blah, blah, blah. I tell them, I say, listen, I go, I know all the experts in the area. Your expert, if we file suit and you litigate this, your doctor's not going to be able to say this. You're going to have to go hire a lawyer, pay a doctor, and I've crossed all the doctors. They're going to admit what I'm telling you is true. And even if you can find a doctor who's going to say that, and we know there's a couple out there that'll kind of say anything, or maybe more than a couple, that the jury's not going to believe them. That's going to be a load of bunk. So I say this all the time. I say, you can tell me that now, and I get that this is in your talking point, Miss Allstate Adjuster or Mr. Geico Adjuster, but here's the deal. Your expert ain't gonna say that because it's not true. So I tell him, I go, who's your expert gonna be? Because I can tell you, I've crossed them and I know what they're gonna say. These things with and then if there's something about low impact, this isn't exactly on the medical, you really need to be careful though on Stephen's point number one, low impact or no property damage. You got to get into that, because for me in litigating, that can be a deal killer. You got to be careful about that. So I literally had a case just this week where I'm looking at the pictures and I call the client and he starts talking to me about how the car went under his. And if you look at the other car, so then I made the insurance company, they went give me the pictures of the other car. My guy's car isn't that damaged, but boy, that other car looks terrible. I settled a case. Genevieve settled a case for a friend of mine, a great guy, Randy O'Berry, where that was the same deal. He had a paint truck. It was on 270. The pictures of his truck weren't good. But if you look at the other car, it was terrible. So think of other ways. Remember, as lawyers, they're always throwing up roadblocks in front of us. It's our job to get around them.
As a young lawyer, it's very difficult to find out if what they're saying is truth or not, because you haven't done a lot of cases when you first start out. When they tell you these things, sometimes you may think, well, that's actually like a well-accepted rule. And then the more that you do this, you realize often it's not. Often it's something that they are using to try to get you to settle early. And often the guidelines that they're using are very, very favorable to their position and not necessarily, as you said before, doctors.
Are you going to say the word bullshit?
Something like that.
Yeah. All right, maybe you won't. All right, so but remember that too, true. But remember, sometimes they may be some of the things they say may hold water. So you really got to listen. What I tell people and the people who work with me is, you got to listen. Is what they're saying true, or is it bogus? And you assess it with the facts on your side and be a strong advocate.
Yeah, sometimes your clients may not tell you everything about a case. Sometimes that's the liability actually, where they may not know a fact and the adjuster tells it to you later on and you think they're just maybe embellishing something, find it later like, oh, that's actually a very important fact.
You mean like the marijuana in the medical record from the, and then you got to go and you take their facts and you got to go back to your client with them. Some of them may be true, some may be not, because you also need to control your client's expectations, control the adjuster's expectations, anchoring, they control the client's expectations too. Sometimes, this is my segue into your fifth point. Okay. Here it comes. Sometimes though, remember, you may get an adjuster who's just never going to do that. They're never going to go with you. Then you got to file suit to me, or you have to do other things like adjusters, supervisors, or other ways to get the case out of that. You're stuck in that box. You're never going to get out of that box. You got to get out of that box and do something different. What's point number 5?
So point number 5 is not in every case you do this, but on certain cases, you may think of one you have right now, right to do it on. You can call the supervisor of the adjuster, but I urge you to do it sparingly and to have a very compelling reason when you do it. And my strategy for doing this is find out the adjuster's email address, supervisor email address, and their phone number. I email maybe 2 or 3 pages of real smoking gun type evidence over to them, and I follow that up with a phone call later, and I want them to look at that as I talk to them. Because that is often a more persuasive way to do it than calling the adjuster, the supervisor, and saying, "Hey, I think that your underling messed up here," and the worst strategy really is just to be arrogant and mad. And I think some lawyers I hear do this often. They call the adjuster and say, "Well, this is clearly $100,000 in this case. Why aren't you paying?" And be real forceful with it. And I think that's never a good strategy. I think the best way to do it is to appear reasonable to them, and to, as I said before, back up what you're saying with records when possible.
Great. So we're running short on time. Anything else on point 5? Yeah, treat them with respect, even if they're a little bit disrespectful to you. Sometimes I do things like, listen, because I have some years, I have my beard, I have a gray beard now, and I got to bring young, good looking people into these CLEs now. so you gotta, sometimes I say, listen, I can tell the adjuster, I go, listen, you've been doing this a long time, I can tell. Or I say, how long have you been doing this? And they tell me. I say, listen, you've been doing this, I've been doing this, here's the deal. Your doctor's gonna say this, mine's gonna say this, blah, blah, blah. Let's get into this range. Or I say, what's the hang up? Or you try to get to what their hang up is so you can get around it. And don't be afraid to ask them, why aren't you paying SWAT in this case? What am I missing? Because if they tell you, because they want to get an answer, they want to get that concern assuaged, or they want you to tell your client that so you can change your expectations and evaluation. I love when you're talking about your dad, and your dad in this section too, by the way. I really like that. How your dad would make me be a great, my dad too. My dad, I get more and more appreciation of him being so nice and kind and measured to people. I need to be more like him. But anyway.
Me as well.
Good. Well, being a little bit like us makes us good lawyers too. So, so I like going to the supervisor. You got to be careful that it can be non-insulting. You say, is there a way to do this? Are you able to talk to your supervisor? Can you? Or the other thing to get to a supervisor is, let's say they're at 20 and you want them at 25. You say, can you go get more authority for 25? I know I'm at 45, but if you offer me 25, I can get it. Will you go ask your supervisor for that? And then you see what you do. I did that the other day. I don't want to make all these other days, but I did. And they got from 20 to 22.5, not 25, and we settled the case.
They may be able to get some more money, though. That's the point. And
some people like it, and you'll figure out the insurance bill. The adjuster will tell you, say, nope, I've already talked to my supervisor. This is all they're going to give me. All right, fine, no worries. But sometimes I go, you know what? You bring up some good points. I don't know if my supervisor knew that. I'll go talk to them about it. The other thing, though, too, is filing suit always changes adjusters and always gets a fresh look. And I always get these, no, you file suit. And is it a pain? Yes, but you pay the filing fee, you get suit, you get service, and then you have an adjuster calling you saying, hey, I know that number we said we'd never pay you 2 weeks ago, but now we're going to pay you.
I mentioned this tip.
What's our bonus tip?
Lastly, real quick, for all these tips, your client tolerance for litigation, how long you want, or they want the case to go, can drive a lot of these strategies.
Yes. There's a tension between good money and quick money.
Right. So sometimes you have clients that want the case done fast, and your job is to find that optimal level of justice and quickness. And I think the adjuster card is a good one to use in certain situations.
Steve, I have a question for you.
What's that?
Why do you want to treat all medical providers as lien holders?
Well, it will allow you to get your client the most amount of money from the settlement as possible, and allow them to get a check that has no liabilities on it. They don't owe a random hospital bill or imaging bill. It's the best way I have found over time to pay off liens is to I don't often negotiate them, especially if I'm able to get a high percentage of their bill from the settlement. If you're able to pay a lien holder 60, 75% of their bill, I often send them a check for full and final payment with the account number on it. I include it with a letter saying why they're getting what they're getting. They will cash that the majority of time without fighting you at all. And I do the same thing with non-lien holders. I put them in the same bucket. And the reason why I do that is, as I said before, you want your client to get the most of the settlement as possible. And sometimes the math works out where they will be getting less if you have to pay the non-lien holders after paying the lien holders first. So you can't in every case. That's why I almost hesitate to mention this as a practice tip, because sometimes you do have other liens that you can't pay a reduced rate on without negotiating. There's things like your risk of health plan benefits or your child support liens. I'm not advocating you do that if those two things are involved. But if you have the rest of the bills, you calculate their amount that they're going to be paid using Missouri lien. And so long as you are honest and doing it fairly according to the law, you shouldn't have a problem getting everyone to fall in that bucket that's meant for a third of the settlement.
Can I add to that?
Sure.
You don't want your client calling you up 2 months after a settlement and saying, "Oh, I got this bill too." Oh, we didn't get this bill. How come you didn't pay this bill? So take care of all the bills in every settlement. I do those two things too. Now sometimes you have times where you're using the Missouri lien reduction statute. You're doing other things. In those situations, you're going to want to I send letters saying you have a lien in this case, and then I wait 2 weeks, and then I send them a thing under the Missouri lien reduction statute where they're only getting X amount. Sometimes too, though, when we're walking to a mediation, a bigger case where we know we're going to have to cram down the bills, we do send letters ahead of time saying, will you take a 50% reduction? Here's why you should. We try to get a feel for who's going to agree, who's not going to agree, because you're going to want to know accurate lien amounts in the mediation. You do not want to settle a case. You want to reach out to lien holders because you could also have $20,000 more on a lien that you didn't know about. So you want to reach out before, especially in bigger cases. You don't want to settle a case and then have to explain to your client why you didn't know of $20,000 in liens or something like that. ERISA liens and I treat ERISA liens and air flight liens the same. I try to cram them down like everybody else, and it usually works. Child support is totally different.
Can't be sure about a ERISA lien. It depends on the plan provider.
We had a good CLE 2 years ago on this. Phil Tatlow did it, and I talked about it too. I also have some other material on how to negotiate liens. That's a whole nother. That's a CLE in itself.
It is, yes.
There's a lot of things to talk about in that. But I think it's a really good point. The other thing is use the liens to get more money from the adjuster. You say, listen, you're offering me 25 grand. I got 22 grand in medical liens. Are you kidding me? Get with the program here, and you show them the liens. You show it to them, just like your other point. Be transparent on that issue and show it to them. I think just to close the loop on this, using some of these techniques enables you to get quicker resolution with cases in the claim stage for more money. Fair?
That's fair, yeah. Every case you can use them for. Some cases you have to litigate. Sometimes the injuries are ones that require further investigation. Sometimes liability requires further investigation. But the other cases that you have clients that maybe want to get it done quicker, consider using one of these strategies.
Stephen, thank you so much for doing this CLE with me. Really appreciate it. Thank you.
Yeah, thank you for having me.
Go go to the Gerring Law Firm on Google, or I'll put Stephen's email address in my comment bar too when I get a minute.
If you have any questions, feel free to email me. Happy to talk to anyone.
All right, everybody. Thanks, man.
Thank you.
We're going to take a short break, 5 minutes, and then we are going to start up with presentation by Genevieve and I in just a little bit. Thank you.